with our roll call.
Absolutely. Jason Amesco,
Present.
Dr. Bolton,
Here.
Jay Frickberg,
Present.
William Hunt,
Present.
Paul Kramer,
Present.
Kevin Marshall,
Present.
Philomena Yaroshek.
Present.
All right, we have a quorum.
Thank you. We'll begin with public comment. Members of the public can make written public comments submitted through the csbars@calbar.ca.gov email box. Written public comments were received and distributed to CSBAR's members already. Verbal public comments of up to 3 minutes will now be taken, first recognizing any individuals who signed up in advance using the link on the agenda, or by raising hands using their raise hand function on their computer within Zoom, or by pressing *9 on a phone. Staff will share a timer on the screen during comments. Do we have anyone wishing to make public comment?
We do have public comment, so I'm going to allow the first person I see to speak, and that person's name is Amy.
Hi, good afternoon. I'm concerned about a case or cases being tried by Kendrick Moxon. He had gone against a person pro se by the name of Scott Hochstetter and another person last name by the name of Daniel Vieta Gonzalez. I would suggest that you read the ruling by the judge stating there's been a lot of misconduct on the attorneys. The way the attorney handled the case was improper, introducing evidence in an improper manner, coaching the witness to make up lies, using lawfare to go after people that were protesting against Scientology. So I would suggest that you examine this attorney and the way they conduct themselves with the cults that is known for I'm out of my asthma's bothering me. Child trafficking and human trafficking as well. Also,
Can we
I would
pause
like
the timer for a minute?
Yes.
Thank you. Just as a reminder to the public, if we can, please keep remarks focused on items within the CSBAR's jurisdiction, would be specifically law school education. If we could now restart the timer and allow Amy to continue.
Absolutely.
Additionally, I would like you to look into Heidi Soto. She's the city attorney. She needs to be looked at as well because she's not enforcing a restraining order against a minor. The minor had served a person with a restraining order that was making sexually explicit comments online and threatening that they were going to rape him. And if the person's name is Tony D'Amato, and she's not enforcing the restraining order because the person already violated that. And I don't understand why she's not going and issuing an arrest warrant. The judge, I don't think, is able to issue a bench warrant. I don't know why the judge hasn't done it. They have videos of this person's continuing the behavior that's prohibited within the restraining order. I would suggest that you look at that, and also Heidi Soto's history of working with the cult of Scientology to practice lawfare and do prosecution against Josiah Adler and Henry Marini, because they have cases that if this were in any other circumstance, that Heidi would not go after them. Thank you. I'll yield back my time.
Right. We have our next public comment from Dean Jessica Park.
Thank you. Just want to check that people can hear me. Hello to, okay, thank you. So hello to CS Bars. I'm here to comment related to item 7.1 on agenda. And first of all, I just I do want to say I'm thankful for the recognition for service in my past CS BARS member term. And really being here, I'm in full support of the new appointed members to the Registered Law School Dean category as we're going through this important topic of discussing those roles. Thank you to staff for sharing my prior comment that I had written to CS BARS in August. ALU is very much looking forward to this proposed registered law school process in order to give the stakeholder input, kind of see that the rules and proposals going forward have a good data basis. And we are just interested especially in topics that are really new for the registered law school category, such as the minimum MPR and this suggestion that the 90-day period students need to be discontinued if they have not registered with the state bar yet, just as a distance learning category school that has to maintain continuous study rule, 52 weeks for each student. If we don't have the ability to see, really on that 90th or after day, they're registered or not, or some way to look into state bar system. We really want to avoid stopping students, especially if they could end up losing up to, 50 weeks. It just depends on when they are. I think, of course, if a student's starting earlier, and this is coming up, it's going to be a more limited amount than that. But I think just when those kind of rules are being considered, please consider like where there might be irreversible actions the school has to take, and that it has to be based on good and accurate data. And any help from staff to do that, if that is something being proposed and implemented, would be important. ALU just continues to sort of await the discussion here. We understand that there will be focused discussion, perhaps on more points that may be on what's written. And so we have circulated with registered law school deans just to be aware of these important forums for stakeholder awareness and inputs. And I hope to provide a well-informed public comment for this Friday's CBE meeting. But thank you for this opportunity. I didn't have that much to say. I'm just an eager observer and supporter, and definitely look forward to supporting the group. And that's my Oscar music, so I will stop, but thank you for your time.
Our next public comment is from someone named Mona M. Mona, can you hear us? So let's wait another moment or two to see maybe something's wrong with it.
Hello?
Yes, we can
Yes,
hear.
can you hear me now?
Yes.
My phone decided to mute me all of a sudden. Sorry about that. Thank you for the time to be able to speak with you today. I would like to talk to you about continuing education credits and for the possibility that there are some attorneys that are getting older that need those continuing education credits, maybe some distant learning credits or distant learning possibilities. What I'm specifically talking about is when to maybe recuse themselves of improper behavior. There's a certain attorney, Kendrick Moxon, who was representing Scientology. And this is one of the scenarios that he condones for a person to get into the guise of a nurse or a doctor in a hospital or a medical facility to the point where they can give an order or a direction to try and get somebody in trouble to fair game themselves. And this is a good chance that these older attorneys that might need to relook at what constitutional law is and how they need to recuse themselves from certain matters that are going on. So thank you for the time to speak with you today. I appreciate it, and have a wonderful day. I yield back my time.
Very much. We have no further public comments.
Thank you, and thank you for the public comment that we have received. We'll move into our chair's report. To start off, I just want to welcome our new members. We have Dr. Bolton with us from the Committee of Bar Examiners, and Deans Ameskua, Hunt, and Yaroshek. I'd also like to thank our continuing members that are still here. That would be our committee member Kramer, as well as Dean Marshall. And an extra special thank you to Dean Park, who participated in our public comment for her service on this committee. I was asked to touch on one of the areas we discussed in our prior CS BARS meeting concerning AI, artificial intelligence. We covered this in our last meeting in August. We spent about 10-15 minutes in a conversation, a dialogue led by Ms. Leonard in this area. Again, just as a refresher, we were focused primarily on the discussion of integration of artificial intelligence topics in law school curricula and faculty guidance for the use of artificial intelligence in law school exam development and grading. I think we had a good conversation within our committee concerning that, especially the distinction between generative AI, which most of us are most concerned with, as compared to machine learning. You know, the generative AI is definitely the focus, I think, that we all would like to have more information on, especially concerning cost, training, confidentiality. The confidentiality being, again, my biggest concern. You know, as generative AI learns, it's learning from us, and we're giving away our information, or sometimes even our clients' information. So I think it's something we have to be very cautious of. Within our conversation, some deans within this committee referenced that their schools are developing or have already adopted AI programs. But I believe all schools were just exploring the use of AI and generative learning as it related to creation of exams or grading of exams. I personally mentioned I have no faith in that myself. You know, our current experiments were not very productive in that regard in the slightest bit. So I think that would cover everything for me within my report. I'll turn over now to our director's report, agenda item 2.
Great. Thank you so much, Dean Frickberg. It's a pleasure to see some returning faces and, of course, some new members. So thank you all for being here. I just have a few updates that I want to share both for our members here today and also for our law school stakeholders who may be watching today's meeting, particularly around our California bar exam experiment, the February 2025 bar exam, and some opportunities to provide additional feedback related to the law school education space. So let me just start by saying that over the last few weeks, I think there has been a great deal of discussion between law school deans and other administrators and staff here in the Office of Admissions. And so we greatly appreciate the opportunity that we've had to speak with you all, to address questions, to hear feedback and concerns about some of the changes and new opportunities. So some of what I may be sharing today might be redundant because we've had opportunities to provide updates, but I think it's important that we share with you the most up-to-date information on these topics. So why don't I start first with the California bar exam experiment. The big update I think to share today is that the application to participate in the experiment closes in less than a week on October 13th. We had meetings on October 2nd, Q&A sessions, both with law school representatives and also a meeting of applicants and students. They are highly productive. I think we helped respond to 300 questions. But one of the questions that came up most often, particularly from our applicants, was when will applicants know whether or not they are able to participate in the experiment? And so I wanted to note here that the application will close on October 13th, and shortly thereafter, we will be emailing applicants to confirm their participation. The 13th is a Sunday. Monday, the 14th is a holiday. So October 15th or 16th is our target date at this time. Those notifications will be sent via email. And as a reminder, we have added a second day to the bar exam experiment. So Saturday, November 9th is now available, will be available. In that email confirming selection to participate, applicants will also receive scheduling instructions where they can go online and schedule their experimental exam on either Friday, November 8th or Saturday, November 9th. Turning to the bar exam in February 2025, I just want to note that the application opened on time on October 1st. So we're happy to say that very little disruption there as far as the normal course of action for applicants to apply. The changes to the February 2025 bar exam, notably the remote and test center administration model is still pending final approval with the Supreme Court. So at this time, the application that opened on October 1st features a question where applicants will select their preferred modality, whether it's remote or in person at a small test center. So that addition to the application for the February 2025 bar exam is in anticipation for a final approval for those recommended changes. Lastly, I want to just put on the radar of both the members here today and again, our other law school stakeholders, that staff will be distributing to law school deans an invitation to join a listening session hosted here in Los Angeles. And that listening session is a meeting of the Committee on Legal Education and Admissions Reform. This is going to be hosted by the Conference of Chief Justices and the Conference of State Court Administrators. And the purpose of this listening session is to provide recommendations to state Supreme Courts, the American Bar Association, law schools, and really other related stakeholders, recommendations at improving bar admissions and legal education as a whole. So I will be in attendance, and I've been told by the host of this event that the voices of law schools themselves are highly valuable in this discussion. And so please keep an eye out for an email from State Bar staff that will have information about this listening session and instructions on how to RSVP. So that's it for me as far as updates. I appreciate the opportunity to share with you these most up-to-date information about these programs.
Thank you. I will now turn over to agenda item 3, our staff report.
Staff report is actually going to be skipped today in deference to the update from Ken Norse and to provide additional time to discuss the rules.
And we do not have a committee report, so we'll move on to our session minutes. The session minutes have been prior distributed. I presume everyone's had an opportunity to review them. I would then ask for a motion to adopt, or is there any discussion to correct the proposed minutes themselves?
I'll move to approve.
I'll second.
Can we have a roll call vote, please?
Yes. Jason Amesqua,
Yes.
Dr. James Bolton, Dr. Bolton,
Yes.
William Hunt,
Yes.
Paul Kramer,
Yes.
Kevin Marshall,
Yes.
Philomena Yaroshek,
Yes.
and Chair Frickberg.
Yes.
All right, with 7 yeses and 0 nos, the motion passes.
Thank you. We'll move on to agenda item 7, business. This is our discussion of rule revisions for unaccredited registered law school rules. I will turn over to Ms. Leonard to begin that conversation.
Thank you. Before we do, I'd like to just present 2 additional items. The first one is we've invited Chantel Slusher from the eligibility unit in admissions to talk about best practices in the practical training of law students, as well as some best practices that she's noticed in participating in that program that can save students time and money. Thank you, Chantel.
Can everybody hear me?
Yes.
Good afternoon, everyone. My name is Chantal Slusher, and I oversee the Practical Training of Law Students program, also known as PTLS.
Sorry, everyone, just give me 1 minute to bring this up. There we go.
For those who are not familiar with the PTLS program, the Practical Training of Law Students program certifies law students to provide legal services on a restricted basis under the supervision of a licensed California attorney who is active and in good standing. To be eligible to become a certified law student, an applicant must have successfully completed 1 full year of studies, a minimum of 270 hours at a law school accredited by the American Bar Association or the State Bar of California, or both, or have passed the first year of law students exam. Students must be accepted and enrolled in the 2nd, 3rd, and 4th year of law school in good standing or have graduated from law school. In addition, they must have either successfully completed or be currently enrolled in and attending academic courses in evidence and civil procedures. Next slide, please. The Practical Training of Law Students program has 3 types of applications. Number 1, Practical Training of Law Students application. Number 2, Practical Training of Law Student extension date only. And number 3, PTLS extension supervising attorney change. I'll be going over these applications briefly. Next slide, please. Practical Training of Law Students application. This application should be filed when the applicant applies to participate in the PTLS for the first time, or a returning student who has changed their employer. Upon submission, the application must include a supervising attorney declaration and a dean declaration. For this application, the current fee is $60. For any additional attorney, it's $30. The State Bar of California does not offer waivers for this application. Next slide, please. Practical Training of Law Student extension date only. Use this form only if the student will be extending the time indicated in the original application or returning to work under the same attorney. There are no fees for this application. Next slide, please. PTLS extension supervising attorney change. Use this form only if a new attorney will supervise the student at the same location or employer. The current fee for this application is $30. For any additional attorney, it's $30. We have identified a recurring issue with this application. Some students are mistakenly adding their previously approved attorney to this application. As a result, they are being overcharged, and we are having to process refunds for this application. To avoid this issue, please remind students that only the information for the additional attorney should be included in this application. Next slide, please. We have made a few updates to both the dean and attorney forms. The checkbox have been removed from both forms to smooth the process, allowing you to smoothly fill in the grades and sign with greater ease. Please note, we are currently still accepting the old forms, but would greatly appreciate if the new forms are submitted. Both forms can be found on our State Bar website and in the students portal. Here is the dean's form, the new. Next slide, please. And here is the new form for the supervising attorney. Here are some tips and tricks. As a reminder, all students must be registered with the State Bar before applying for the PTLS program. Please be aware that the beginning of the semester is our busiest time of the year. We kindly ask for your patience. If students have any questions or concerns regarding their PTLS application, they are more than welcome to submit their questions through their portal. Thank you, and thank you for your time.
Thank you. Ms. Leonard?
I just have a couple of questions for Chantel about the program. So when people are looking to sign the form, is an electronic signature requested, or should they be printing it out to do that signature and then scanning it back to you?
That's a good question. Unfortunately, yes, they will have to print it out and sign it and upload it to the case.
And if they have an electronic signing, such as DocuSign or PDF signature that's got the timestamp on there, will that be acceptable? Or you prefer the written?
Either one is acceptable. We accept both.
Okay, great. And then to clarify, when you talk about registration, that law students must be registered in order to participate in the PTLS program. This is the registration that all of the students are encouraged to do within the first 90 days of their law study. So hopefully they've done so well before. And another advantage to that registration is that they will not have any delays in their PTLS application.
Correct, yes. So if the applicant register first and then apply for the program, yes, they will not be any issues moving forward with their application.
And you mentioned that law schools can access this form directly. Do you have any advice, or are there any special considerations for law schools that may be wanting to submit bulk applications to you?
Yes, so if there is a bulk, they can go ahead and send it to me on my through my email. Or they can actually send it through the students portal if they choose.
Okay. And when a law school is submitting them to you in bulk, is the way to effectuate the payment to include a check?
Yes, so they can do a check, or they can go through the portal, which is much easier. But either one is fine, checks or cards.
Okay, so a law school can themselves, for this particular application, go on and use the portal in order to pay?
Correct, yes.
Okay, great. Thank you. And then are there any deans here with us that have any questions or have had experiences that they want to share about having your students participate in PTLS? Dean Yarashak.
I do have a follow-up question. When you're talking about the school going directly through the portal, you're talking about the students portal.
Correct, yes.
And I will have to tell you, I'm not, would we have to know their password, etc.? How does the dean get, or a school get into the students portal? As last time we tried, there was not a way for the school to get through that portal.
Okay, so unfortunately, the school will not be able to go directly. It would have to be through the student. So just go ahead and submit the form with the student. The student will have to upload that form through their portal.
Okay, so it sounds like a best practice could be for a student to submit themselves through the portal, or alternatively, if a law school wants to submit it on the student's behalf, they could send it in along with the check to our Los Angeles office?
Yes.
Okay, perfect. Thank you.
Just one question on my side. I was curious, I haven't done the bulk application. Typically, for my school, we have about 20% of our students actively in PTLS. It's a great program. I was explained to them that sometimes it's better than electives they can take, to actually be in the field and working. And especially for new lawyers, if they're not sure what area to practice in, they could volunteer at the DA's office, the PD's office, that they can move around. If we're doing a bulk application where we email that directly to you, I presume we have to have all three documents: the student app, the dean's declaration, as well as the supervising attorney for each of them.
Correct, yes.
Excellent. Thank you. That's it for me. Any other questions from our committee members? Not hearing any. Thank you for your time. And it's an excellent program. I wish we could expand it. There's a similar one for the federal courts. Totally different rules, of course, in the federal court system. I think there's no better education than a practical education.
Thank you guys and have a great day.
Thank you, Chantel.
So moving back to our agenda item 7.
We have one more. We're bringing to you Ken Norse to talk about some of the free programs available to help state bar applicants. So I'd like to welcome Ken Norse, who's in the process of being promoted, so he can address everyone. Ken, welcome back.
Thank you so much. It's great to see everyone here. Please bear with me while I share my screen. I just have a brief presentation. I want to make sure that we have all of our facts and figures straight here. Just a moment.
As he's putting that together, I'll just thank the members of CS Bars and also the members of the Law School Council. We were thrilled to see a little bit of a preview of this and to see how much the second iterations of some of these programs have been shaped by your feedback.
Absolutely. Thank you so much, Natalie. I'll be talking about 3 programs specifically. The brand new ADHD strategies program called Refocus that we're actually just in our 3rd weekend as I speak. The Reset Bar Retaker Support Programming. I'm preparing for the February 2025 bar with that. And then I also wanted to mention a resource that's available to all of us, which is the Overcoming Imposter Syndrome Toolbox. So let's begin with Refocus, ADHD Strategies for Success in Law. This program was developed in direct response to requests for ADHD-related support that we received from many different directions. This is a pilot program that we're currently running. It was developed after extensive consultation with DC Bar, the DC Bar Lab, the New York Lab, and the Minnesota State Bar Lab, all of whom are running ADHD programming for attorneys, law students, and bar applicants. Our current pilot is running on 6 consecutive Wednesdays at 12 noon. Our idea is to catch people during their lunch. It's running from September 25th through October 30th. We thought that was a good time just before the holidays to maintain everyone's attention. Registration was capped at 1,350 attendees due to State Bar Zoom license limits, but we reached that cap within 48 hours of announcing the program. So I can tell you that there is a huge demand for this programming. It doesn't surprise me, having joined the State Bar from a George School of Law, where we saw a large percentage of students who had ADHD or who believed that they might have it. So I was really blown away by the registrations for the program immediately. So we have developed, each session is topically themed. I wanted to make sure that we were focusing on very practical and actionable areas. These topics were created in conjunction with the Lawyer Assistance Program therapist that I'm working with to produce this ADHD strategies programming. She's been with the lab program for approximately 20 years. The topics are motivational regulation, working memory. This week, we're going to focus on emotional regulation. Next week, I'm actually trying, because this is a pilot, I'm going to be experimenting by having a guest speaker join the therapist. So we'll have 2 people presenting on planning and problem solving, then inhibition and impulse control, and we will end with self-awareness. I'd like to, so although this program is absolutely full, it is a pilot program. I would like to encourage law students and bar applicants who are interested in future LAP ADHD programming to visit the Lawyer Assistance Program offerings page and to sign up for email alerts. If I were going to search for this, I would just go to a Google search bar, put in State Bar of California, Lawyer Assistance Program offerings, and you'll see a list of the current programming as well as a link to sign up for those email alerts. And I do expect, given the huge demand for this programming, that we will see another cycle of ADHD support programming in the new year. Of course, we are paying close attention to the program evaluations for each session. I can say that for the working memory from last week, over 90% of the participants found it to be incredibly helpful for them, and a similar percentage would recommend this programming to others. So I'm really looking forward to continuing to expand this programming and based on attendee feedback, among other things. So that's the Refocus program. The next program I'd like to talk about, I'm now calling Reset. And this was not intentional. Reset was actually taken from one of the session names of the pilot that I ran for the July 2024 bar. So we will be launching the February 2025 bar retaker support program registration in November. We are working with a new platform for the state bar called Zoom Events, and it's great. Unlike during our pilot for those 4 sessions, attendees had to sign up separately for each and every one of them. Zoom Events allows attendees to sign up once and be automatically registered for each and every session. Communications will, as last time, include email invitations sent directly to qualified participants. I'm also working with State Bar Communications to develop social media postings, and I love cross promotion by law schools. I do intend to provide anyone who's interested with a one-page information sheet that can be referenced for the retaker program. The program timing will be a total of 5 sessions. We're actually adding one more session than the 4 that we had for the July 2024 cycle. These will be held weekly from December 2nd through the week of January 13th. We are taking off 2 weeks for the holiday period. And these sessions will be held on Mondays from 6:30 p.m. to 8 p.m. We're making them half an hour longer, actually, than we did in our pilot earlier this year. We got a lot of comments that attendees felt that the presentation was a little rushed. And so we're expanding it by just an additional 30 minutes to accommodate that. The good news is, so during our pilot, we had lower attendance for the sessions that were specifically dedicated to mental health prep. That was the first one to help retakers reset for studying for the bar. And then in our pilot, we had the last session also be mental health preparation to help them get ready for the big push. Because of that lower attendance at those specialized sessions, instead, we've decided to interleaf mental prep strategies with our study strategies as follows. The 5 sessions will be score interpretation and resilience reset. I have the same presenters as last time. Mary Basic, who is one of the co-authors of the seminal book that everyone uses to prepare California law students, will be presenting our score interpretation. And I'm partnering again with a lawyer assistance program therapist who will be presenting resilience reset. The second session will be focusing specifically, and I do need to change this information based on the new form of the California bar. We're going to call this multiple choice questions instead of MBE. My apologies, I need to update the slide. The third session will be essays and maintaining momentum. This is the session that will take place right before the 2-week hiatus for the holidays, and so we wanted to have some mental health programming to give people tools to maintain that momentum over the holiday period. Fourth session is performance test, and then finally end game study strategies and self-care for the final push. So we really hope that by interleaving the mental health strategies, that everyone will be exposed to them and that our attendance will be a little more even across our sessions. We also will be this time issuing session evaluations before the end of each session to increase response rates. In the pilot, we were getting about 10 to 20% response rates for the session evaluations that were issued after the end of that particular session. I actually tried the strategies for our current ADHD programming, and I can tell you it is a runaway success. We are seeing near 100% completion of program evaluation citizens as a result. So it's a very effective strategy. So this is the summary for our Reset Bar Retaker Support Program. I can't wait to see what we learned from this to incorporate in for July 2025 for next year. And then finally, I'd like to turn to our Overcoming Imposter Syndrome Toolbox. This is a syndrome, shall we call it, that affects many different people in the legal profession, but especially, first-gen students, maybe people who have no attorneys in their family. The official definition was a common challenge among high achievers in the legal field marked by self-doubt and difficulty in accepting one's accomplishments. It can actually happen at any point in our career, but we wanted to make this available, make this known to everyone on this call so that you might point appropriate people to this toolbox. This toolbox guides attorneys, law students, and employers through understanding and overcoming imposter syndrome. It includes things like worksheets and resources for each of these groups, and it's available right now on the State Bar website. One easy way to find it is by going to a search bar, putting in Overcoming Imposter Syndrome Toolbox, or you can visit this unfortunately somewhat unwieldy website, but it is Overcoming Imposter Syndrome Toolbox. So that really ends my overview of the three things that I wanted to mention. Are there any questions for me?
Not hearing any, I would have one similar to the one from our last meeting back in August. I think you're doing an excellent service for our community. I think a lot of times mental health and these issues, most are afraid to even raise or think about. So by bringing this from the bar's perspective, I think it's very helpful in normalizing the conversation. My only ask would be, is it possible to share any of the materials? Similar to the imposter syndrome, where you share a lot of materials there, I think for attention deficit or retakers, is it possible to share those materials with the public or with the deans of different law schools?
It absolutely will be, in creating toolkits based on our experiences through the pilots and the first or second of these sessions. We are seeing in our program evaluations exactly what's the most common issues are, for example, exactly what connected with people. So it is on our timeline of things to produce. This is really new and innovative programming. There really aren't many other bars doing this, and I want to make sure that we get it right. So rather than release, anything half-baked at this point, we are continuing to solicit input through these iterations. But I'm so glad you asked about that, because having a toolkit that would be available for others to use for any of these areas is definitely in our plan.
Absolutely. Thank you. Any other questions, comments from our committee members? Not hearing any. Thank you, Mr. Norse. Great work. Please keep it up. And so now I believe it's safe now to turn to agenda item 7. I'll say cautiously. And Ms. Leonard, if we could start that discussion. I don't know if you want to bring up the slide deck.
There we go. Thanks, Dean Frickberg. Yes, so what we'll be doing is showing a slightly modified version of the presentation that was shared with the Committee of Bar Examiners back in August. And we've divided up some of the key changes that are included in this proposal for further discussion today. If something is not specifically noted, it still is something that you can comment on. We did provide a full set of the proposed rules out to the deans prior, just after the committee meeting in August. We received the public comment that was shared with CS bars, and we welcome additional public comment, whether verbal or written. Okay, thank you. So let's go on from the title page. And though my name is there, really, this is really a joint presentation of everyone. And I appreciate the work that each of the members of CS Bars has done to prepare a piece of this discussion. So how did we get here? So many of you know that the accredited rules have been revised. They're through their transition period. They were implemented in 2022, and the safe harbor period ended at the beginning of this year. You may know that this is part of a larger effort under which all of the admissions rules are undergoing a standard periodic review. Back in 2022, we signaled that this project was beginning and requested feedback from CS bars about topics to consider, and several topics were considered and included in part of this proposal, not only for the rules, but also for court rules, specifically related to the libraries. In getting ready to think about the changes, the Committee of Bar Examiners was able to look at data in the form of the Law School Performance Report and the Law School Profile Report. They were presented to the committee back in August and December of last year. After each of those presentations came here to CS bars so that the same data would be shared. After looking at the data, both the committee and then later the CS bars discussed the priorities of the committee that were raised after looking at the data review. Several specific priorities were identified. We'll talk about those in a minute, and some of them are already in the introductory draft, which was shared in August at the Committee of Bar Examiners. So that's where we are today. That draft was shared in August, and it's brought here to CS bars today to discuss each individual piece. We're interested in any feedback that you may have about the proposals. Do they address the topics that you feel to be a priority in running a school? Do they address those priorities in the most effective way? And are there other revisions that you think would be appropriate given the current state of legal education? Next slide. So today you'll be providing the feedback on the proposed revisions. You'll see that there's a discussion leader for each section, but we welcome your feedback on all of the sections, whether or not you are the discussion leader, and we welcome your additional suggestions. And I thank in advance the CS bars members and member pairs that will be leading these discussions. Next slide. Overall, one thing that we'll be doing, and if you have suggestions there, we do encourage you to send them in, is just to make sure that we use consistent terminology with what we've seen throughout the admissions rules, as well as the accredited rules, just to improve clarity. We're consolidating definitions where it makes sense and making sure that the distinction between rules and guidelines is clear, that rules set requirements and guidelines interpret those requirements. Next slide. So we'll talk about each of the groups individually. The first group relates to revisions proposed from the accredited law school rules, and these are around the area of the non-compliance process. So currently in the unaccredited rules, if a school is going through a compliance challenge, there is a process in which first they make a response to an inspection report, and then second, there is a non-compliance process, which requires repetition of some of the steps in a very short period of time. So the goal here is to consolidate those pieces, provide one streamlined process that is clear, that still provides enough time for a law school to respond, to request a hearing if possible, but doesn't require the law school to do double work while they're working to rehabilitate the issue. So I'd like to turn it over to Dean Marshall to talk about, to lead a little bit of a discussion around that area and how it's been going in the accredited rules section.
Thank you for that, Natalie. And if you all would bear with me a minute, I started this kind of analysis based on the topics that we got in the email, Natalie, and I started with 4.240A15, 4.241A through B, which then took us all the way up to 4.260. And I just made a couple of comments and observations with respect to those provisions first. When I looked at Rule 4.241, I know this deals with the disclosure statement that could lead up to a non-compliance scenario. I made a couple of comments. First of all, Rule 4.241A2, requiring the school to disclose whether it's applied for accreditation or not. I'm concerned about that from a consumer protection division. I'm not sure how that's relevant to whether a student is in compliance with its registered standards. And I think if you require a school to disclose that it has applied for accreditation, it could present an overstated consumer issue about, well, accreditation is just around the corner. Or vice versa, if a student is required to disclose that it's applied, it's pending, or it's denied, it could then confuse the conflated term of accreditation with its registered status. So I point that out because I think this could create more confusion in the consumer marketplace. Not sure I understand why it's relevant to a registered school's registration. So I throw that out for conversation. I also wanted to point out under A 4.241A6, the disclosure requiring the number of legal volumes of a library. I think that provision should be reworded or rearticulated. I'm not sure the number of legal volumes, what that might mean in terms of providing value to a consumer trying to assess whether or not this education is of quality or not. You have the term, the number of legal volumes in the library and the scope of electronic resources. I think that could be reduced to disclosing the scope of their physical versus digital libraries, and you could accomplish the same thing. In 4.241B, if I could direct your attention to paragraph 2, the disclosure statement must be provided to each new statement. That's paragraph 1, but paragraph 2, each returning student prior to payment should also be provided this disclosure statement. And there's a phrase in there, the disclosure must still be updates. I think it's a spelling error, but it raises this question. I like the idea that we should be disclosing to the consumers of this product the status of the school and the robustness of the school and its many offerings. But this disclosure statement, is it timed? Is it time stamped? Because if we're going to require it be provided to each student upon admissions and then at each additional academic term, one, that seems like a lot of bureaucratic work for a school, but two, there's this reference, is it supposed to be updated in the interim of the annual disclosure? So I'm not sure the rules provide a clear, articulated timeline in terms of the timestamp of the disclosure or the status of the school. And then if these are to be redisclosed with each academic term, is it real-time disclosure and updated or not? Because I think that's at least entitled to a conversation and to the, again, bureaucratic burden that could create in terms of running a school.
Dean Marshall, would this be a good moment just to touch base and potentially also to address some of the questions?
Absolutely. You
So
stop
keep
me
going.
when you think it's a perfect breathing time.
Oh, no, I'll defer to you. And also another possibility that we have for everyone is to place up on the screen specific rules that we are talking about. The first thing that I noticed was your comments regarding the application for accreditation. So that's a standing rule right now. It can be one that's open for discussion. Does anyone have any other additional question or concern about that current requirement, which is letting students know whether or not the school has applied for accreditation? Dean Marshall raised the possibility of overstatement or confusion.
Do you want us to raise our hands? Sorry, Natalie. Would that be easier? I just
Sure.
unmuted myself and
Sure.
I think that as to that particular focus, as the idea that it also says what the status is of that application is critical, right? And so, yes, has the school applied for accreditation? But if that was it, I would very much agree with Dean Marshall. But I think that it's the when was it and what's the result, right? And I think from a consumer perspective, it's important if the accreditation has been granted or it has been denied. So I think that second half of that sentence is critical. The pending, you're right. If it's just pending, then does it have to then be updated? I think that's part of the updated disclosure issue.
Thanks, Dean Yaroshek. Okay. Not seeing any other comment. I think that the question about the legal volumes, I think also it's self-explanatory. Oh, Dean Mesqua.
Yeah, sorry, I wasn't sure if we were moving on from to the next section, but within this section, something that Dean Marshall didn't mention that I wanted to point out also was the 2.241A number 4, the disclosures of the financial reporting. I do understand that the majority of these disclosures echo 6061 and the Business Professionals Code. But this seems to be an addition like the one we were just discussing. So I would, as a nonprofit entity and knowing multiple schools that are, we do have a requirement for our tax information to become public. I'm not sure of the value of putting these kind of numbers out there on a regular basis and as widely as they currently as this would expect it to be on a to our own students and to prospective students. I also think we should be mindful of the other entities, school entities that may be for profit, as well as business practices revealed in our financial statements and things like that. So if there is it could present some clarity to what exactly the financial statement would consist of, for perhaps maybe mirroring more some kind of modified version that would be acceptable, and not necessarily a full detailed as like we submit in our annual reports and during inspections. I think that would be something that should be considered as well in clarifying what exactly should be regularly put out there.
Thank you.
Yeah. Paul?
Yeah, sorry, my video crashed. I'd have to reboot my machine to bring it back up. And I didn't want to leave out hearing part of the discussion. Regarding disclosing that there's an application for accreditation pending, I can see that cutting two ways. Some might be worried that a school is going to use that to inappropriately market themselves. But I don't know that we could say you can't talk about it until it's approved. because that would probably be a free speech issue. So it's more of a question than one that I have an answer for, but people who are going to fudge things are going to fudge things, and spin and puffer. So maybe it may still be better to let students know that there's the possibility of this coming, if for no other reason than if they have some concerns about the school's ability to meet our standards. They'll be on notice that there's perhaps somebody they should be talking to about those concerns.
Thanks, Paul. Okay, I want to move on to Dean Marshall's comment about updates. But before I do, I just want to put a frame around this disclosure rule. The legislature has required that for unaccredited law schools, this disclosure rule has serious consequences if it's not followed. If it's not followed, a school can be required to refund tuition back to students, or can be required even to have its registration withdrawn. And of course, we're working to make sure that it's very clear so that schools will effectuate their requirements under this, and neither of those will ever be triggered. So when we're looking at these points, we're looking at it in that context to be very clear about what the triggers are so that they can potentially be avoided. And so Dean Marshall was asking about, yes, you are correct, Dean Marshall, rather than updates, it should say updated. Some of the thinking behind that change was that currently this disclosure is created once per year. And this requirement has been in effect for a long time. When information moved more slowly, this was created. And now a school can have additional bar results, primarily the changes that you see during a school year are bar results, or potentially, occasionally, unfortunately, a notice of non-compliance status. And so the hope is that these disclosures could be updated, usually, most likely just in those areas, before each term. So there's already a requirement to provide it before each term, but the thought is to update those two areas. So I don't know if that addresses or modifies your comment in any way. I want to turn it back to you and the group for larger discussion.
And before the group discusses this, I think for me to articulate my concern is, again, the clarity of what needs to be updated in real time. If it's the entire disclosure, I mean, and it's to be updated on a term basis, that seems to be a pretty heavy lift. Not that we shouldn't be lifting if we're regulated, but it seems to be a pretty heavy lift. If it's just the bar pass rate, or because that's a moving target, as you know, in terms of putting that number together, and also in terms of attrition, that's a moving number. So I think in terms of using a real-time updated obligation, maybe more clarity from my perspective, but I leave it to the committee now.
That's really helpful. Thank you. Dean Hunt, I saw your hand first.
Thank you. Really tied into that, to update our disclosure statement, we run on trimesters. So it's a 4-month semester. We update ours 3 times a year. It is a bureaucratic administrative responsibility, but we add in the new bar results, the new first year law students exam results. If there's a change in faculty, sort of those being the main areas that we'll focus on. And then the things maybe dealing with student teacher ratio or anything else that's more big picture, the financials, we do those annually at the beginning of each year. So we sort of do a modified update 3 times a year, and then release that each trimester to the students to sign and submit back. But tying also into Dean Marshall's comments, when looking at section 2. What is it? I want to make sure I've got the right numbers. 4.241B1 2.1, where new students are to sign, or actually are to be provided a disclosure statement prior to paying the application fee. If that is to be signed, I think it should say that there, because it does say that in B2, but not in B1. And it's one thing to say, hey, we should give them the disclosure statement, but later on we'll get a signed version, or do we want a signed version as well as the application when the application comes in? I understand the idea with the disclosure is they've gotten it before they give the school a penny, which makes sense. But if it's going to be a signed one, maybe that should be added to B1 as well.
Yeah. Dina Mezcua.
So my question was just a point of clarification, I guess, for Dean Frickberg and specifically Dean Marshall. I know that your area covered 2.2 or 4.240 A15. At some point, are we going to be able to comment on 2.24 A in general, or in other specifics? Should that be during this time or in a different section?
I'm sorry, 2.4. Yeah, I started with 4.240 only because that was what I thought I was assigned in the conversation. So yeah, we can circle back to that. And I didn't want to spend too much time on these, but I did, since it was part of my assignment, I thought I should at least give the observations, share the observations that I had. Because I know that Dean Hunt and Urakashek are going to deal with the disclosures as well. So I'm kind of being duplicative here, and I apologize for that.
No problem. I think this this requirement is such a base level important requirement. It's terrific to have this engagement.
So again, the updated piece, the reference to the update, making sure we understand what we mean by that update. I did note the disclosure statement for every term and the required signatures. Again, I think there should be a little bit more conversation about what is going to be required. Is it the disclosure and an acknowledgement that a student had read the disclosure statement, or a signature that they've been handed the disclosure statement, or that they've actually signed the disclosure statement? I just make that note. For example, there may be a process where the school is required to archive this disclosure statement on the website, and that's where the real-time change takes place. And then there's an acknowledgement of having read it, but I don't want to go deep into those details other than to point that out. I would also throw out the refund for non-compliance. I ask this question that is a huge draconian discipline, and I respect it and would certainly support it. My question is, what happens to the credit hours? You know, if there's a failure to get a student to sign the disclosure statement, but the student is successful in law school and the student has credit hours, what happens to those credit hours? Do the students still get the credit hours even though they haven't paid the tuition? There's a sense of equity here. Or what if a student, didn't get the disclosure statement but has no complaint? Or I just throw that out. Non-compliance could constitute termination of the registration, but a student could go on and graduate and become a lawyer from one of these programs. And so then I would ask the question, should that student get tuition-free reimbursement? So
And here the hope would be that if there is a problem, it's discovered in that particular term, with the idea being that because money shouldn't be expended before it's signed, the school would not be receiving the fees in that term, and that should certainly trigger the school that something is going on, rather than having the student study for a long period of time.
Right, but you would discover the non-compliance post non-compliance, right? So a student has been, all the students may be enrolled, and the school has dropped the ball with regard to getting them to sign the disclosure statement. I just throw it out there. I think there could be an issue about what happens to the tuition, or excuse me, the credit hours that have been earned or in the process of being earned. I think that's all I have with regard to the disclosure statements. If anybody wants to comment further on some of those points, and then I would move on to the process of 2.460B. Any comments?
I see
I'm
Dean
sorry,
Yeroshak's hand. I see Dean Yeroshak's hand.
Dean Yeroshak?
Yeah, thank you. I think what you just mentioned about the consequences of non-compliance makes it so important, critical, that what is required has to be super, super clear. So I come up with, especially in this section, the 4.244.1, is when must the disclosure be provided? When must it be signed? And what must be included? Right. So in those, the first one, when must it be provided? B talks about when it has to be provided, right? To each student, to each returning student. And sorry, I forgot who made the comment about B2 having information about signature. I would suggest to clarify that subdivision C should have all of the information about when it is signed so that it's clear. B says when it must be provided. C says when it must be signed. And then A is what must be included. I know that's just a structure, but structure is important because when, we're reading at this and just the comment that was made, well, B1 doesn't say must be signed. Does that mean then it doesn't have to be signed there? And so I think if we really keep it tight just a little down right there. Exactly. So in B, sorry,
Yeah, a little bit.
Yes, there you go. So if you have B1 saying a disclosure statement must be provided to each new student as part of the application and prior to the payment of the application, there's a question there about, does that mean twice? Because do they pay at the same time that they're making the application? So I think that needs to be clarified. And then 2, each returning student prior to the payment of any fee for an academic term. And then I understand including quarter, semester, or summer term. I would then suggest that second sentence, if a law school changes, charges, I think it's charges once per academic year must still be updated. Oh, the disclosure must be updated, provided, and signed. I would suggest that second sentence, be moved to subdivision C so that you have all of the signatures in one subdivision, if that makes sense. So you keep it, what must be disclosed, when must it be disclosed, and when must it be signed?
Thanks, that's helpful, and I hope it's been helpful to put up the rules so we can follow along.
I know
and
this
the
is
public can follow along at home.
this is in the weeds.
But this is very important, and these comments are very welcome, so thank you. This may be the very most detailed part of the rules suggestions because of the nature and because of the triggers.
Okay, then I would move us to Rule 4.260, Notice of Noncompliance. And the highlighted notes that I wanted to just throw out for conversation is, first of all, I noticed in terms of the timing of the due process that's taking place, the receipt of notice of noncompliance, the responses, etc. I noticed that it's 15 days. Schools have 15 days to respond to notices of noncompliance, and the committee is afforded 30 days. Now, whether it's 15 or 30, 15 seems like a tight bandwidth. Within 15 days of receiving a notice of compliance, a law school must file a response demonstrating its compliance. I would just ask, are those dates appropriate? 15, 30, in terms of dealing with something that's so consequential and important. I would also think it would bear goodwill in the sense that unless there is a reason why the agency should get more time than the school and vice versa, there should be some kind of equity in that notice process. Second thing I'd point out is with respect to
Before we go further, Dean Marshall, might I ask, you talked about the appropriateness of the time period. Do you have a thought about whether the 15 days is appropriate, and if not, what you would find more appropriate?
Well, I think 15 days is 2 weeks. You get notice of noncompliance in 2 weeks, and the school's got to immediately respond to and demonstrate how it's in compliance or make adjustments immediately, or find the data that might be missing to demonstrate it's in compliance. So I don't know. I would certainly want more time if I was a school, and the only thing I would say is I noticed that the committee is given 30 days. So why not 30 days for both parties?
Thank you, that's helpful.
With respect to Rule B1, where it says if the committee deems the response satisfactory, shall notify the school within 30 days. B, what if the committee doesn't notify within 30 days? Is there a default phrase? What if, in other words, if the committee fails to respond within 30 days, the response is deemed satisfactory? Something to incentivize anyway, a response from the committee. To be in that kind of silent purgatory waiting for a bureaucratic declaration could be very harmful to an institution, its program, and even its students. I throw that out for conversation.
And I see Dean Yaroshek's hand.
Oh, I'm sorry, I didn't see
Well,
it.
I previously did. It looks like it's come down.
Come down. Sorry. I'm a rule or regs geek, so I apologize if I get too much in the details and in the weeds. But a possibility, whether that 15 days as a suggestion, is that because I think the bar is going to want that response fairly quickly if it's something that is the non-compliance is very egregious. Hopefully that doesn't happen. And sometimes the non-compliance may not be as egregious. And so do these regs want to give both the law schools and the bar some discretion with a 15 to 30 day leeway, right? So that gives and again, it's discretion on the bar staffs and the bar, right? But it also would give a little bit of more time, the ability of a school having 30 days to prepare. You know, if there's a lot of, I think the language, sorry, I'll look at the language specifically, must file a response demonstrating that it's in compliance, or detailing the plan to reasonably demonstrate that it is going to be in compliance. That could take a long time, right? So I do think 15 days can be, especially if it's calendar days, not business days. So those are some other options of clarifying, either providing a timeline up to 30 days notice, and then if not, then clarifying that these would be business days, not calendar days.
Okay, thank you. Dean Marshall, I'll turn it back to you. It looks like you've got the paper copy there.
Yeah, I do. My notes. Just a couple more comments on this area. I in reading all of this, you know, but this is more a 30,000-foot level of this area. If a registered school's registration is to be terminated, I was looking for the phrase "a teach-out plan." You know, something that would assure an easy landing for now I think it's implied in the language, but maybe more clarity about if that registration is ultimately terminated, that there will be a teach out, something that's going to protect the students, or is this an immediate cease and desist and leave everybody kind of wondering, or from the consumer's perspective, what do I do?
So some context may be helpful here. I think that your reference may be the ABA approved schools that are generally attached to a university that continues, even if it doesn't continue in a law school context. And what we've often found here is that the school doesn't have the intent or sometimes even the ability. But what is also true is that there's a greater amount of flexibility for students to exercise free will and transfer to another registered school than we would find in the ABA context. And so that's generally how it's been handled. There generally hasn't been the reasonable resource available from the point of view of the accredited school. And so requiring it has not historically been realistic.
So I understand it might not be realistic, but right, I mean, that's always the case in almost every lawsuit, whether a judgment's recoverable. But I guess my question is, why not require that expectation and obligation that a school who's going to become a registered school or be in the business of a registered school understand that they have that obligation? Now, at the end of the day, it might be impossible, but I do think that's responsible regulatory approach to expect it. Yes, Dean Hunt.
I understand your point. I know there has been a number of schools over the last few years that have ceased operation. And I think it's a double-edged sword. Obviously, there's this idea they should honor their commitment to the student. They should teach out. but at the same time, that also may not be what's in the best interest of the student. The schools that have a discontinued operation, a number of them over the last few years, it has been primarily due to first-year law students' exam results and bar results that were virtually non-existent. And giving the students who have started there but haven't completed an opportunity, notice that the school is closing, and the opportunity to go somewhere where they may have a better chance at succeeding on the first-year law students exam or the bar exam may be beneficial to the student as opposed to a hindrance.
No, I would agree with you. I don't think it's mutually exclusive, right? A student, a program could offer the teach out and the student could say, I'm out. I don't want the teach out. I don't trust the school anymore. I don't think it's a mutually exclusive option in my world. Yes, Dean Yurashek.
Sorry, just going back to that paragraph B, as a law school, I would want to know exactly what I need to demonstrate in my response. And so I think some of this language may be a little unclear or vague. It says detailing a plan that reasonably demonstrates the law school's best intent. And so I would have just, as if I'm recipient of this non-compliance, I would want to have very specific. So I would suggest specific language that says that detailing a plan that reasonably demonstrates the law school's specific steps it will take or has taken to return to compliance. And the timeline of the steps to return to compliance. That just is a little bit more concrete than the language that's currently there. That just, again, just a suggestion for concrete clarity.
Thank you. Another, if I can move us to 4.264 probation. Timeline for reinstatement was my note. In terms of probation and reinstatement, my note is I'm looking at paragraph E. Committee may remove a law school from probation prior to the conclusion of the probationary period if the school demonstrates compliance with these rules. Maybe some language regarding the process. School could ask for expedited removal of the probation and something that would enclose this process into a closed space from a temporal perspective. Here just the committee may remove, but we're all sitting and waiting to see. So should there be some language about nudging the committee through a process for expedited removal? And then I would just close with these comments about the termination of registration under Rule 4.265. Committee may terminate. When I look at paragraph 2, they can terminate if the school is out of compliance. So I'm throwing out what kind of, any compliance, a significant compliance, a compliance that prejudices the consumer, a compliance. I think we captured in 3, right? The law school is engaged in, is out of compliance, that is serious, could harm the safety, health, and education of financial condition of the students. For example, 2 would give broad discretion to the state bar of any type of non-compliance. including failure to get students to sign the disclosure statement, even though the school is a robust and fundamentally good school. So maybe, what do we mean by out of compliance that would give us a little bit more of a criteria about what would be that draconian kind of into a school? And I have taken up a lot of the time. I apologize. Those were the provisions I looked at. I noticed, Natalie, on your PowerPoint, you had a couple of others that I didn't look at yet. And so I apologize. I think it was on that PowerPoint 2 point, I don't know. Anyway, I guess that this yields so we can have some discussions on some other provisions as well.
Okay, but this, I think this is the thought of what we most needed to discuss together. So I think this is terrific. Okay, so are there any other thoughts on this area before we go back to the PowerPoint and set a frame for the next discussion topic?
I just want to make a comment on the last one.
Excellent.
If we can put that back on the screen, please. It was rule 4.246, I believe. The out of compliance comment. There it is, 4.265. So that was A2. I felt comfortable with that just because that last sentence fragment, and the committee finds the probation would not be appropriate. I thought that was the safety valve, that it wouldn't just be a technical violation. They didn't have a signature on one form and there goes their registration. So long as they can evidence that probation would be appropriate, it's curable, it's fixable. That's why I was comfortable with that section. And I had one that was in the similar area, but a little different. If we could pull up rule 4.245, formerly 4.246. So that's why I was looking in that area. And just as a comment, this is under 4245B. B is in Bravo. And again, this is from an earlier conversation as well with the accredited rules, similar to the accredited rules. So under B, changing the location of law school's administrative office, campus, or classroom facilities, I would offer as a recommendation more than 5 miles. Again, that's similar to what the WASC standard is. It's similar to what the accredited school standard is. So if a school is moving under 5 miles, it's not impacting their student body, their faculty, their staff. And I wouldn't believe that requires a major change, which again, for a smaller school is a major expense as they go through that process. And that was it for me in that area.
A helpful context comment might be that what we've sometimes seen here is not only a move in distance, but a significant change in resources as between the locations. And so I think that's part of what's driving the continued current practice here.
No, understood and appreciated. Just wanted to toss that out for the dialogue.
Okay, perfect. Okay, so we'll go back to the PowerPoint to talk about the next section. And I will just issue a blanket thank you to everyone for this thorough review. This is the sort that is needed, but does take an investment of time, and the investment is greatly appreciated. Thanks. So next we'll have Deans Hunt and Yurashek. There's a little bit of overlap. We've already started to talk about the consumer disclosure in the form of the 4.241 disclosure. There's also the 6061.7A disclosure. There is no additional change proposed to that one. Also just talking about the financial information for schools more than 10 years old, and we already have a comment from Dean Amezcua regarding that, about clarifying what should be provided when and where. Requiring a student complaint policy, which was outside of the assignment, so I'm happy to address some key points of that at the conclusion of the discussion, as well as clarifying major change requirements, from which we've heard one comment from Dean Frickberg. So let's start with the areas of Dean Hunt and Dean Yurashek, and then we'll circle back to complaint and major change.
most of my comments, my review, I made the comments during Dean Marshall's very great review of 4.241. So I think from my perspective, I have some minor clarification language, adding a period here to making it 2 sentences, nothing substantive. I think Dean Hunt was taking that part of our presentation.
I'll have to concur. Really, I had my list of issues to discuss. I thought Dean Yershak's idea of how we would compartmentalize when the disclosure has to be given and when it has to be signed seems really appropriate, so that that's clear. I guess I also had question, or I'll reiterate my comment with that Dean Park, who came in as a public comment, the 90-day rule for students to register, that there's no way for us as a law school to check on that. And so I guess we would be dependent on student verification in order to let them continue on past the 90 days. It would be nice if there were a way to verify that. And my last area from reviewing the rules, where it also does tie into Dean Marshall, the library requirement. I mean, it tied into the volumes. Aren't all the students really just doing it all on electric database research anyway? Even if it is a residential school, I don't know how much students are, going up to the second floor and finding the Cal App second and going through it. They're going to be Lexis, Westlaw, Fastcase, Google Law as well. A lot of our students have started using. And I think maybe there should be a reputable electronic database for legal research requirement, as opposed to some discussion of volumes.
And toward that end, I think that's an extremely logical suggestion. We can go back and check the statutory construction underlying it and to see what we're required to do under the statute. And if a discussion as to the statute is helpful, though outside the jurisdiction of state bar. Great point.
Okay, thank you. Those were the 3 big things that jumped out at me: being able to verify that the student is registered, when the disclosure statement gets signed, and the database. But otherwise, everything else we have addressed.
Thanks. I see comments from Dina Mesquat and then Paul Kramer.
So I don't want to beat up this topic too much, but I did want to just add a little bit of context to the 2.240.013, which is the 90-day that Dean Hunt is mentioning. So it does appear that this is outlined in the Business Professionals Code 6060D as an applicant responsibility. And to the point, 6060.25 of the Business Professionals Code restricts the state bar from sharing admissions data from your sources. So it does seem that there's a conflict in, where the method by which that information is collected in terms of students of lost students registering with the state bar within that 90 days, and the addition of this rule puts moves that burden to the schools, and which would put us in a position of having to give negative consequences for students that don't follow this. When it's a state bar rule, it's an applicant responsibility, and there's no consequences on that side. The other piece I would mention is that this is a financial expectation. It does cost to register. There's a $100 plus fee for registering, and I think that includes checking the pre-legal education of the applicant. So we're additionally putting a restriction on or adding a burden on students and a penalty for not financially taking on this role. And I don't disagree that it should happen within those 90 days. I just don't agree. I just question, the wording in the version of the addition to make it a school responsibility for compliance.
Natalie, in the registration system, is there some kind of receipt or something that the student could print out and give to their school?
Yes, there is a confirmation that they can share with the school. Part of the reasoning behind this is, first of all, a consumer protection element. It's a further assurance that anyone studying has properly met the pre-legal requirements before they start. But second, it's a way to make sure that the State Bar can communicate with the students in any situation of school non-compliance, situation of opportunity, such as the chance to participate in the experiment. And, two possibilities were considered. One, the registration possibility, and another, simply an additional registration that might be required before any student could be enrolled. And part of the thinking was not to establish yet another registration requirement, but to simply prioritize one that already exists and is of great benefit to the students for consumer protection. So I thought maybe that context might be helpful to the discussion. And Dina Mesco, I'm not sure if your hand is newly up or if it's from prior.
Yeah, it's new. I to your point, then I would just either as a outline it in this rule or in some other fashion, the collaboration between the potential ability to collaborate between the State Bar and the school to help check on these on students and these numbers. Yes, the students can once they do register, they very typically willingly give us the numbers. However, I am aware that it's not just an unaccredited school issue. It's an issue of tracking these numbers down from students from an ABA and accredited schools as well.
In Yerushak, I don't see any additional hands. Shall we continue?
One question in that same area.
Terrific.
And again, as was brought up, it's been a continuing issue on the accredited school side, and I presume at the ABA side as well. Is it possible to create a validation where we can receive the admissions number that they receive upon registration as a law student at the State Bar and confirm that with staff at the State Bar? And again, just in my personal experience, students often misunderstand. When I have the conversation with them, you have to register as a law student. Well, I am registered as a law student. I'm in your law school. That's not what we mean. And we have to register as a law student with the State Bar of California. And because it goes through the portal system, they sometimes do not understand how that works. So if we could ask them for their admissions file number and then send that maybe to a staff member just to confirm that admissions file number has registered as a validation system, check and balance, as it were. I don't know if that is possible.
And I'm not quite sure. I definitely see what the issues and suggestions are, so we can do some research and see what is currently possible or what could be possible. Because we've heard quite a number of comments in this area. Okay. Any more comments on this topic, or shall we proceed?
There was one similar area, if I could bring up, under 4.205. I know that wasn't assigned to anyone. 4.205.
Yeah.
And I'm just thinking as a bureaucrat, how could we evidence this? How can we comply with this and go through that process? As written, I understand that the schools would have to create their own policy, but looking at 4205C, a law school must maintain comprehensive records of all complaints. Being a former law student, being around law students for the last quarter century, they love to complain. And we teach them to advocate to complain, to advocate for themselves and their classmates. Is there a way of separating out informal versus formal complaints? Or is that something that should happen within the school's own written policy? Because I can't imagine we would want professors to document every complaint from a student. This classroom is too hot. This one is too cold. I understand the purpose and meaning behind it, but I'll make sure we comply with whatever the requirements are, at every school level.
Okay, that's a good point.
I always thought my degree was in cynicism, but should there be some time limit on the maintenance of these records? Literally, you have to hold these forever, and 10 or 20 years seems long enough, doesn't it?
That can be something to look into, and I can see if there have been times when it's been valuable to have this for a longer period. Excellent. Shall we move to major changes? And I can take that one.
Please.
Okay, so major changes, the main thing that was suggested here is that for registered schools, there are specific hours requirements. And so we wanted to make it very clear that one of the places in which a major change is requested is when a school is changing the total number of hours in its program, or the display, the progression of the program. So, for example, moving from a semester to one course at a time, or a semester to one quarter at a time. Quarters and semesters are the options for registered schools. Reason being, we've seen largely good faith errors in the hour counts that create potential concerns for students in terms of their ability to claim credit for the year going forward. So having schools apply for a major change, largely for the purpose of staff and the committee to confirm that it's within the hours requirement so that students can properly continue to earn credit, we think would be an important consumer protection element based on issues actually seen in practice. So not so much for the committee to have a controlling opinion as to whether semesters or quarters are correct for a school, but having made that selection, making sure that the students can earn the credit that the schools in good faith attempt to provide and allow them to earn. So that's the main issue there. I'm guessing there will be no particular objection to that, and seeing none, that's the last part of this section. We can move on back to the PowerPoint to the next section. And we are at 250. So we will get through. We have a couple more. Let's see how far we can get, and we can extend just a little bit. We can probably get through the materials. Do people have availability to stay until about 3:15? And if so, does that raise any concerns for our council?
I have another meeting that starts at 3 o'clock. It is Zoom, so I will have to leave this one at 3. I'm sorry.
Okay.
We can go a little past our 3 o'clock, but if we lose quorum, we should resume at the next meeting.
Okay, understood. Okay, so
Natalie?
Yes.
So Dean Park, I don't know if this is the right place to raise it, but Dean Park raised the issue of having to put in a full year's worth of time to earn any credit. And I know it's something you and I have talked about in the past, whether we could allow partial years credit and make that administratively possible. I wonder what the group thinks about that. So if somebody can do a semester's worth, for instance, and then has to take a semester off, why should they lose the whole semester's worth of work?
Okay, so I think a couple clarifications may be helpful there. So the school can set up a semester schedule right now without any type of change. And some schools still choose to set a full year calendar, giving grades only once a year. So they can go ahead and make that change. And they are allowed to build breaks into the calendar. They're just simply asked not to front load or back load the courses. So having a whole year, but doing all of the coursework in a tiny space of time where success is not very likely.
And is that allowed under the rules? Because I thought there's at least one rule that requires you put in you measure any effort in terms of a full year's worth and not in any lesser increments.
The guidelines talk about the ability to split that into half-year segments, and that's been allowed for quite some time.
Okay. She thought it was a problem, I guess, but you're saying it isn't.
I'm happy to follow up with her directly, and then we can see if there are additional concerns here. Seeing that we are at 2:50 and we have several additional topics, I wanted to see, coordinating with the chair, if instead of extending the meeting today, if you would be open to scheduling an additional meeting, understanding that we would need the 10 days notice in order to do that, in order to announce it to the public so that the public can continue to follow along with us. Is this something that Chair Frickberg, would you recommend? And if so, we could do a poll of availability offline.
I would definitely support that. My only concern is, does it have any downstream impact on CBE meetings? You know, I think we're having a good, robust conversation on all these topics, and hopefully that would be helpful for the CBE in their review. So I would definitely support it as long as it doesn't cause issues for them further down.
Great point. The good news is this feedback is not intended for this week's CBE meeting, so it need not be completed at this moment. We could look for a date later on in October that's workable for the team. Is that something we're open to?
I would support that.
Okay, great. And that also gives us time to do some research on the questions that were posed today as well. Okay, so shall we continue? We have 7 minutes. Shall we continue in the section that we are on?
I think we should. You know, we have the time already calendared, and we have the benefit of everyone's minds and focus on everything they've read and prepared for this meeting.
Okay, great. I also think it's really good to put up a frame for this next topic and be able to think about it while we are away. So the statute requiring study for unaccredited law schools contemplates two categories, a fixed facility category and a correspondence category. These were all created pre-technology, and at that point, fixed facility was everyone in a physical classroom being taught in that manner. And a correspondence situation was essentially receive a box, complete the assignments in the box, send them back at the required intervals. As technology evolved, in order to differentiate those correspondence schools from distance schools that had some interactive element, a distance category was created in the state bar's rules. That required 135 interactive hours, so fewer than a fixed facility school, but more than a correspondence school. As technology has continued and as the legal education and education fields in general have changed since COVID, there's been a need to review these possibilities and to think about mixed modality potential options available as well. There's a consumer protection element to be clear to students so they understand the type of study that's available and the type of study that's required. And the state bar is required to operate under the dictates of the statute. So there's a proposal here that I would turn your attention to, and perhaps Dina Mesbah could talk about it briefly and pose the questions to think about that could open our next meeting.
Yeah, absolutely. So you set it up pretty nicely, so that definitely saves part of what I plan to present. But the main thrust is this modernizing of the terminology between the asynchronous and synchronous. I do believe that the technology aspects has blurred some of those lines between correspondence and distance learning. And the one thing I would stress to on the record was for the other unaccredited registered schools that are correspondence and distance learning to look at these categories and encourage public comment for how they believe this would affect their current processes, because I think everybody might do it a little bit differently. My perspective is that it does make sense that there is these two modalities, and it just might be in the way where current schools are actually operating within those. Will there be enough flexibility between asynchronous and synchronous to allow, with little disruption, to have to adjust what they're currently doing? And the only other piece I would say to consider is this idea of the continuous study requirements that are part of distance learning categories of 48 to 52 weeks. These because they're online, the idea is they should be spread out over a longer period of time versus versus the 12-month period where under the fixed facility you could do 270 hours, but as long as anywhere within those 12 months. So there is a little bit of that difference, and will that need to stay, that with now having the two different categories? Is a continuous study requirement necessary, or how do we ensure protection of the experience, that things are linked, there's an appropriate spread out of material and instruction amongst an annual period, but giving the flexibility that asynchronous and synchronous study, the options provide. So those would be my two my 2 points of thinking and getting insights about it, and start that discussion when we meet the next time.
Okay, perfect. I appreciate that frame, and I do think it's worthy of some reflection. In setting a new date, we will be sensitive to the first-year law students exam coming up, so we will look to avoid those particular dates. We'll be sending something around to see what can work for everyone, and looking to post something as soon as possible, as soon as we get it confirmed, so that can be posted right away and shared with all deans and your teams at the schools. Dean Frickberg, any parting thoughts or comments?
Just thank you, everyone, for your donation of time and the seriousness of our conversation. Again, I think it benefits all of our communities in California, and trying to bring more into the practice of law, which is all of our goal. And with that, we'll stand adjourned.
Well, thank you. Thank you, everyone.